Hello, my name is Julianna, and this is a presentation on privacy rights. According to the Constitution, in the beginning, there was not an exact statement that gave individuals the right to their privacy. Within the 1920s, the right to privacy was not taken as seriously as it is today, and when Justice Louis Brandeis described the policy rights as the most comprehensive of rights, the right most valued by civilized men, many of his colleagues did not feel the same way. When the 1960s began, privacy rights started to become more seriously taken into consideration within the Supreme Court, and due to a case in 1965, Griswold versus Connecticut, it was ruled that entering the premises of another individual is trespassing and goes against the rights to privacy. The right to an individual's privacy was then stated within the First, Third, Fourth, Fifth, and Ninth Amendments. Privacy rights are guarded under multiple federal statutes, including the Constitution. Privacy rights have also expanded to protecting individuals under tort, consumer, internet, and employment law. Stated under privacy rights are multiple federal legislations that also give individuals their right to privacy. HIPAA, Health Insurance Portability and Accountability Act, was passed by Congress under privacy rights. HIPAA was created to share with patients their rights on how their medical information should be used. Within the Act, there are various regulations such as an individual's medical information cannot be given to others without permission and cannot be used for other purposes other than medical reasons. HIPAA is also enforced by the Federal Trade Commission, and anyone who violates will end up with a fine or jail time. In addition, HIPAA is enforced for electronic and non-electronic medical records that are transferred from one physician or medical facility to another. In addition, another federal legislation is called the Privacy Act of 1974. It was created to protect any individual's information. If someone wanted to access information that the government may have on someone else, this act would protect it. This act also makes sure the information is not being used improperly and that the individual does have authority to contact the agency where the information is being used, access it, and ask how they are going to use it. The Electronic Communications Privacy Act of 1986 is the final federal legislation we are going to discuss, and it protects communications that are electronic, wired, or oral during the transfer of personal information. The Federal Wires Act of 1968 was originally due to the interception of telephone calls and interrupting conversations. However, when the Electronic Communications Privacy Act of 1986 was created, it then added electronic communications to keep up with the age of technology. Therefore, it protects any form of personal information that is stored and communicated electronically, wired, or orally through the phone or in person. When it comes to the healthcare insurance provider Athena, not only do they violate HIPAA policies, but the Privacy Act of 1974. The first violation occurred on July 28, 2017. Athena had placed 12,000 envelopes with individuals' information that could be seen. On the envelope, it also included a label that declared that within the envelope had medications for HIVs. The second violation occurred 2 months later in September 2017. This violation had affected 1,600 patients and dealt with mailing information as well. Athena sent out information about a child fibrillation study that was conducted on patients. However, they made the logo and name of the study visible and made it suspected that those were the patients being sent the information and that they had a trial fibrillation. When it comes to violating the HIPAA policy, the first HIPAA violation was July 28, 2017, when mailing labels had patient information and context that stated HIV medications were included. The second HIPAA violation was in September 2017, due to the mailing envelope stating the logo, name of the study, and the individual's personal information. The Privacy Act of 1974 was also violated due to the individual's information being misused and misunderstood for the study. In addition, the Privacy Act ensures agencies in protecting an individual's private information, which Athena did not do. Lastly, the Electronic Communications Privacy Act of 1986 was the third violation within the case. When the HIV information was being transferred, there was no consent for the individual's transfer of information from Athena to their legal authorities. Furthermore, healthcare agencies and organizations need to take the time and implement a system where they ensure their patients' information in any format is being protected and their privacy rights are being applied.